Welcome back. Time is 7:44. Some leaders are looking to allow the American people to hold individual ICE agents accountable at the state level. Democrats are looking to allow citizens to file lawsuits against agents when they believe their civil rights have been violated. This comes as protests against ICE continues nationwide following the shooting death of 2 people in Minnesota.
All right, so let's bring in our chief legal analyst, Khalif Rhodes. Now, there is something in the Constitution that does allow people to bring civil rights lawsuits against federal, state and local governments, but this hasn't really been extended to ICE, right?
Yeah, there's something called an accountability gap. That's what they're saying. Yeah, you can bring a claim against agencies, but not individual agents, and that's what the state of Illinois is attempting to do. Those claims typically brought against agencies are going to be under 42 U.S.C. 1983. A 1983 claim is pretty straightforward. It's saying that this agent was acting under color of law. The defendant was a state or local agency, and there was some type of constitutional violation, either 4th, 1st, 8th, 14th, whatever the violation was, and then the defendant caused some harm. If you fall into that category, you typically can bring a 1983 claim. The issue is, can you bring it against these individuals? Illinois is trying to stop that gap from being there. I just don't think it's going to be successful in that attempt that they're trying to do it that way.
And Khalif, these ICE agents, most ICE agents, federal agents, have that qualified immunity. So what are state laws? How do you think they're going to be able to jump that hurdle?
A couple things. So remember, qualified immunity is not law. That's the part that's troubling with this. It's not in statute. It's not something that's given in the Constitution. It's something that's been created through court, through cases, through precedent over the years, where it is this heightened burden that you have to jump over to bring a claim against an official, either civil or a criminal claim like that. So getting over qualified immunity in itself is hard. I think the true issue will be the supremacy clause, that the federal government will tell the state that you can't tell us what to do, that you can't dictate to us on the federal level how we discipline or how claims can be brought against federal officers. And I think that argument may be successful. It's been successful in the past when states have tried to go upwards. The state will argue and say it's just a remedy for an individual to bring a claim towards an officer, but the federal government will argue, and I think correctly, that you don't have the right state to tell us what to do, how to discipline, or how punitive officers should be able to get access to.
Khalif, you often talk about when things go to the Supreme Court, not saying this is headed in there, but you have a case that has all the ripe ingredients for something to go to the highest court in the land. Would this be something where the supremacy clause could be challenged because they're saying we need a way to hold these agencies accountable and we can't trust the federal government to do it?
I think it would have to go there to get an ultimate answer, but this type of argument has been in front of the Supreme Court in the past. The case is called Bivens, where folks have attempted to bring claims, in what the Supreme Court has done has narrowed what Bivens would allow. Over the years, you could bring a claim and it was a wider net. Now, over the years, slowly but surely, that Bivens case has been chopped away after time and time again when the Supreme Court has had an opportunity to view it. I think that if this case ultimately gets there, the Supreme Court, as I mentioned before, would rule in favor of the federal government, because the supremacy clause would be controlling. I mean, when you look at the plain reading of what they're attempting to do, they're saying we're stopping a gap that is not allowing folks to bring a claim against federal agents. Well, that's directly in opposition to what the supremacy clause says they should be able to do as a state.
And you're saying that it's unlikely that this will move forward again with the direction of how they're trying to tell the federal government what to do. But as it stands now, what can people do if they do feel like their civil rights have been violated by ICE agents?
It would be a Department of Justice. I mean, so you'd file a claim with the Department of Justice, and you would hopefully that they would bring a civil rights claim on your behalf. And I know that's asking you to go against the agency that is in some components may have offended you, if it's a connection on the federal side. But that's typically what would be done, that they would investigate and they'd say, hey, there was a violation, and the Department of Justice would bring, their Civil Rights Department would actually bring that claim. And that's why I say this workaround that the state of Illinois is attempting to do isn't what happens historically. And I know that we're in unprecedented times and folks are trying to find novel approaches, but you have to be rooted in precedent, in case law, to get to that result, and this doesn't get you there.
All right, Khalif, thank you very much. Appreciate that.
Queen City News Plus. Just search Queen City News on your smart TV's app store.